The matter before the court is BCD 23-454, Randall Belyea, versus Heather Campbell. We are being streamed live on the web, both by video and audio. Counsel, I see, are present. I'm assuming ready to proceed. I would ask that we start by having you introduce yourself by saying your name for the record together with the party that you represent, starting with the appellant.
Good morning. Jamesa Drake on behalf of Randall Belyea.
Good morning. Robert Ward on behalf of appellee Heather Campbell.
Thank you. And Attorney Drake, we'd be happy to hear your arguments.
Thank you, Your Honor. May it please the court and counsel. This is perhaps the most basic contract case one might imagine. The single question which unites both assignments of error is whether a contract existed between Heather and Randy. And in answering that question, this court will employ a doubly deferential standard of review. First, it will infer all facts and all of the inferences that follow from the facts in the light most favorable to Randy. This court will affirm only if, quote, no reasonable view of the evidence could sustain a verdict for Randy. And of course, here we already have a jury verdict in favor of Randy. The jurors were properly instructed on the law, there's no doubt about that, and the jurors in their wisdom found that a reasonable view of the evidence could sustain a verdict for Randy. The second component of this doubly deferential standard of review is that it has been the law in Maine for a very long time that a court must be, quote, reluctant to construe a contract so as to render it unenforceable. Now, as we probably all remember from law school, a contract exists if there is an offer, acceptance, and consideration. Certainly that was what was drilled into me as I took the class. And we have that in spades here, and the trial court found as much. Offer, acceptance, consideration, that's no problem here. The offer is as follows. The terms were the business would continue to belong to Randy, and Heather would be an owner on paper only. The acceptance, Heather and Randy went to Randy's lawyer's office and transferred all the BEI shares to Heather. And the consideration is that the arrangement allowed Randy and Heather, who were at the time intending to marry, to keep the FedEx contract for themselves. There was no need to, for example, involve Randy's son, Matthew. So what's wrong then? Well, we say nothing. Nothing is wrong. The jury said nothing is wrong. Nothing is amiss. There is a contract here, and Heather breached the contract when she ousted Randy from the company. But the trial court said that the oral contract did not exist as a matter of law because the terms were too vague and thus unenforceable. Now again, the jurors were properly instructed on specificity, and they had no difficulty finding that these terms were sufficiently specific. But regardless of the jury's verdict, we would urge this court to remember, please, this doubly deferential standard of review. Now, our contention is that the trial court's reasoning was wrong in two regards. First, the trial court respectfully misconstrued the arrangement, and we discussed this in our opening brief at pages 23 to 25. The court says that the parties agreed that, quote, nothing would change. And then it goes on to reason that this was impossible.
But didn't things change by virtue of the nature of the circumstances that Randy found himself in? He could no longer hold the contract in his name and be the official representative with respect to dealing with FedEx.
Absolutely right.
So how does that consistent with what you say was the contract?
Because the parties contemplated that the day-to-day operations of the company would change. That was the whole point of their agreement. Randy could no longer be the forward-facing.
And that the ownership would change. I mean, wasn't this really a contract to commit fraud?
It was that the ownership would change on paper only, right? And there was absolutely no fraud here because FedEx was fully aware of what was happening.
Didn't FedEx say, you understand what's happening here? This is a real transfer. And they both said, yes, yes, it's a real transfer. Are you saying that was fake?
And that you're not together anymore, Heather keeps the company, you get that.
So, again, this court will view all of the evidence in the light most favorable to Randy, and reading that portion of the transcript very carefully, it comes up on direct examination, right? And so the question is, well, what exactly is it that Randy is prohibited from doing? He's prohibited from being the authorized officer. And then the question to FedEx, and then FedEx adds, and he can't own BEI. Well, we have two responses to that. The first is FedEx was really in no position of authority to determine who was going to be the owner of BEI. And this relates to our second point, which is that was a point of contention solely between
FedEx
Heather and Randy.
has the right not to do business with this as long as he's the owner. And they say, we can't do business with you as long as you're owner. And so they both say, he's not the owner. And now you're saying he was the owner, just not technically.
I'm saying he was not the authorized officer, which he was prohibited from being. That was what was contemplated between the three of them. Remember, FedEx is not a
When
party.
you say the three, you're saying FedEx as well. Well, you said contemplated between the three of them. I'm just trying to make sure I understand who you say the three are. Obviously, Heather and Randy, and you're saying FedEx.
So, if I may clarify, the contract here only has two parties, Heather and Randy. FedEx is not a party. No one suggests that FedEx is a party, right? So this is just Heather and Randy representing the nature of their agreement to FedEx, right? But that, you know,
if FedEx had to approve that in order for the contract with BEI to continue, which was part of the testimony of representative from FedEx.
Correct. So viewing the evidence in the light most favorable to Randy, and I want to go a step further and provide more in my answer than I have so far.
But before you do, just so I'm clear, ownership was not of concern to FedEx? Could Randy just have been deemed not an authorized officer and kept ownership of the company?
That is exactly what happened. That is our contention of what happened.
Well, he
And
transferred the stock. He transferred ownership of the company.
that was the on-paper only part. And this is the
Well, I think
fact.
his question is do you agree that FedEx would not have allowed them to be the authorized representative had they not transferred, had he not transferred, at least on paper, ownership of the company?
I think there is ambiguity in that regard in the transcript. I really do, because there is this considerable back and forth between the lawyers and Ms. McNally, the representative from FedEx, about precisely what it is that Randy can and cannot do. And what they land on is he cannot be the authorized officer. And here is the additional fact that I want to add.
Then why was she engaged in the discussion with them where she said, this is what needs to happen in terms of the transfer of the ownership of the company, and to the extent that they represented to her that's exactly what they were going to do, and that they understood that the consequences could be Randy saying, I know I'm transferring ownership to Heather. Heather and if we don't get married, it's hers. And Heather responding, well, if in fact it is transferred to me and we don't get married, I'm going to run it as my own.
No, there was no discussion, there was no contemplation at the time that they were entering into contract negotiations about what if they don't get married.
Well, I was talking about the discussion they had with Ms. McNally.
I am as well, right? So the discussion with Ms. McNally,
I think there was actual discussion.
there was what if they break up, which would have contemplated them being married. But I think this is, my larger point here is, and if I may just finish this answer, because I keep repeating the same thing, which is unsatisfactory because I'm not getting to the second part of this answer, which is what was prohibited was Randy being an authorized officer. And all of the things that are cataloged in the brief, wearing the name tag, driving the routes, et cetera, et cetera. But FedEx was fully aware, and there is uncontroverted evidence of this in the record, that Randy continued to be involved with BEI.
Well, getting back to what I think is the thrust of the appeal is whether we say, was this fraud or not, or it's the basis of the court's decision was that this was not specific enough. And what you're saying is, of course it was specific. He's just going to be, it's in name only. Whether or not that could be, that the problem wasn't with the specifics.
Yes, but may I just say, as someone who practices criminal defense, I'm very uncomfortable with suggestion that there could be fraud. I don't know if we're talking about honest services fraud, which has been a hotly contested issue up at the United States Supreme Court. The point is there was no fraud because FedEx was fully aware of this arrangement. But it wouldn't have mattered anyway. We're not here on a case that involves the prosecution for fraud. The question, as Your Honor is suggesting, is were there sufficiently definite terms
Can I
of the
go on
contract?
to a different point then, which is at the time the business was transferred, ownership of the business was transferred to the defendant in this case, did it actually have any value? I mean, it seemed to me the evidence was that there was $130,000, and from both sides, that there was $130,000 in debt, there were some trucks, and that at best, the value of all of the physical assets of the company may have offset the debt. There was other testimony that the debt was greater than the value of any assets. So, I mean, let's assume, I'm not sure what the contract was. I mean, okay, he continued to be involved. I don't know really what the agreement was, what was supposed to happen when after that. To the extent there's a FedEx contract, they can't put ownership back with him, so I don't know what you're really seeking. But even if that's all true and there's a contract, how is there any value in what he transferred to her?
Okay, so what we're seeking is a reinstatement of the jury's award of $250,000 to
what?
Randy. Based on the notion that these two had a contract that was sufficiently definite. And again, viewing all the evidence in the light most favorable to Randy, as a matter of law, doing what it can to construe the agreement so that it finds that a contract exists. Their terms were unadorned, but there was a meeting of the minds. And as it relates to your question about what the company was
Well, what was the
worth,
meeting of the minds as to what was going to happen? Okay, he transfers the company to her. He's doing some mechanical work and there's very little that he's actually allowed to do with regard to the company, but he does continue to do some work. I mean, what was the end game? What was the term of the contract? What was supposed to happen?
So
Was that just supposed to continue that way ad infinitum?
Well, let me sort of correct the factual, I think, underpinning of Your Honor's question. BEI was always more than just the FedEx contract. As Your Honor just noted, it owned assets in addition to the debt that it accrued in its own name. BEO was an entity separate from the contract. But what do we have in the record? Randy, even after the stock transfer, made hiring and firing decisions. He assigned loads during peak seasons, which was done online and not at the terminal. He dealt with the drivers on a daily basis. He fielded calls from FedEx. Again, FedEx.
But is the
fully
breach
aware.
her not transferring it back to him? Is that the breach? What's the breach?
The breach is when she completely cut him out of the company without affording him.
And was there a meeting of the minds that this contract was going to go on for 5 years, which is what he was negotiating with FedEx, what BEI was negotiating with FedEx?
So there was a meeting of the minds that this contract would at least get them through this contract period with FedEx. I don't think it's clear in the record how long the parties intended for this to continue, but of course, the backdrop here is that they intended to be married, so their understanding is that they would be bound to one another sort of in perpetuity. Unfortunately, that's not the way it ended.
Thank you.
Thank you.
Mr. Ward?
Thank you, Your Honor. May it please the court. Belyea Enterprises basically contracted with FedEx Ground to deliver packages in Aroostook County. The sole source of Belyea Enterprises' income was his contract with FedEx. Belyea Enterprises owned some motor trucks. and they employed drivers to operate those trucks. However, all packages that were delivered by BEI were it was coordinated at the terminal of FedEx as to the packages that were to be picked up. The motor trucks were routinely housed at the FedEx terminal. The motor trucks were routinely inspected at the FedEx terminal. The drivers for BEI were vetted by FedEx prior to hire, and the work performance of the drivers was monitored by FedEx representatives. There are cameras in the trucks and other devices to check the work performance. Beginning in 2014, Heather Campbell began providing bookkeeping and account monitoring services for BEI. She also later qualified as a FedEx driver under BEI's contract. In 2016, Randy Belyea commenced negotiations with FedEx for a new contract with BEI. And at that time, he was advised that he was disqualified as a FedEx contractor, and that the BEI contract would not be renewed if Randall Belyea was an owner or officer of BEI. It also indicated that Randy would not be allowed on the terminal premises. He would not be allowed to drive a motor truck that was under contract with FedEx through BEI, and he would not be allowed to wear clothing with a FedEx logo. Now, to continue the contract with BEI, with FedEx, it was determined that Heather Campbell...
Given the posture of this case,
Sure.
Let me focus on what I believe is the issue before us, which there was a ruling that this contract was not specific enough. When one of the parties to a contract says, here were the terms of the contract, X, Y, Z, and it goes to the jury, whether or not the defendant agrees that those were the terms X, Y, and Z, if there is an articulation of one of the parties in an oral contract as to what the terms were, then how can we overturn the jury verdict?
In this situation, as the court found, there are no specific terms, no definite terms, and clearly no meeting of the minds in regard to any contract. Randy's disqualification basically prohibited...
But if one of the parties says, here are the terms, and yes, we agreed, we're not supposed to look at, we're supposed to look at the objectivity of whether there was an agreement, and it's a jury case, it's kind of hard for us to say we're going to ignore that testimony, isn't it?
The testimony is basically that Randy is prohibited from going on the premises. He can't have anything to do with BEI. He can remain employed by BEI.
But did Heather testify during the course of the trial that nothing's going to change? You know, Randy still be the owner. He's entitled to the business profits, and this is on paper only. And did she testify to anything like that?
No, she did not.
What did she claim or disclaim the contract did or didn't?
She basically said that it was her contract. She's the authorized officer with FedEx. She makes the decisions. She negotiates with FedEx.
But
She
what
deals
did
with
she
them.
say about, obviously she and Randy must have had some conversations about this before it happened. What did she testify to about those conversations?
I believe their testimony is that it was untrue, that basically everything was going to change because the contract was in her name, and BEI was in her name.
But why does it matter what she says if it's a jury question and one of the witnesses has said it was X, Y, and Z, that another one said, no, it isn't X, Y, and Z? Why does that matter when it's a factual dispute for the jury?
We've got the testimony of Carol McNally that says, basically, Randy's out, Heather's in.
So you're saying no reasonable jury could believe him as to the specifics of this contract?
Yes.
But you agree, he did testify to that. I mean, he testified that, repeatedly, that the agreement was that they were going to put everything in her name, that he understood there were a lot of tasks that he would not be permitted to do, including going on premises, but that the agreement was that they were doing that so that the business would continue, and it really would continue to be his business. I mean, he testified to that, didn't he?
I suspect, my recollection is that yes, he did.
I understand.
But I also believe that she
disagrees.
testified that was not the case.
Well, but the jury did find it was the case. The jury found that there was a breach of contract and that he ought to be awarded $250,000 worth of damages.
And the court found that, or as a matter of law, that that was not reasonable, that there was no contract.
Well, is unreasonable the standard for a court to grant a JNOV?
Well, the court did grant it, I guess, and
They
the
did.
question is,
Luckily, they did it after the verdict, so if we thought it was incorrect, we could reinstate it, potentially,
yes,
right?
yes.
Okay, so, well, I'll leave it.
So in this instance, if Randy testified that Heather promised that nothing was going to change and the business was still his and he'd be entitled to the profits and all that, if he testified to that, and I believe he did, and the court looks at that, I mean, I don't think the court found it was unreasonable, but simply that it was too vague and indefinite. So I think, don't we focus down on Randy's testimony as to what was said and decide whether or not that is indeed, as a matter of law, too vague and indefinite to stand up as a contract? Isn't that the issue in this case?
I think the issue is that Randy transferred his ownership in BEI to Heather.
Well, if we accept everything he said as to here's what the terms of the contract are, then I think what Justice Meade is saying is that then the issue before us is whether accepting everything he said, there isn't enough in the guts of this contract to show specificity, like how long is this supposed to last? And usually in those situations where a contract doesn't have a term, we say a reasonable period of time. We gap fill. So are there gaps in this contract that we're not supposed to fill that render it too vague in this particular context?
Well, there's certainly no specific terms as to duration, as to the responsibilities of the parties. And when Randy suggests nothing's going to change, everything changed. Because it's all tied to the FedEx contract. And Heather is in control of that. She's the only one that can negotiate with FedEx. She's the only one that can have contact, can go to the terminal premises. Randy can't. And so everything changed. And to suggest that there's a contract otherwise doesn't make sense, I guess.
So the court found that the jury could not reasonably have concluded there was a contract here.
Yes.
And that's the point of law we're looking at here. And we look at the judge's decision on the motion to determine whether or not that is an abuse of discretion. What's our appellate standard of review?
I guess it is an abuse of discretion if that's what you're looking at. But as I say, we suggest that the court appropriately found that there's no definite terms and there's no contract, and that going forward, Randy the BEI stock could not be transferred back to Randy without voiding the FedEx contract that BEI had. If there was some suggestion it was going to be transferred to someone else, the stock in and of itself transfers whatever assets are in the company, but FedEx controls the contract.
But I don't want to flog this any further. I'll take one more shot at it, which is,
Okay.
in this case, the jury obviously found that the elements of the contract were present. That's why they awarded it. And the judge felt to the contrary. So in my opinion, based upon these facts, I would find that they were too vague and indefinite. So if it was tried to the court, Randy would have lost because the judge would have found the facts to the contrary. But on a motion like this, to notwithstanding the verdict, it's a heavy burden upon the person asserting it to indicate that the judge has the prerogative to conclude that the jury could not have reached that result. So you keep responding that, well, the judge found this, the judge found that, but does the judge simply get to substitute his or her judgment, or do we look at whether or not the evidence is sufficient to make a reasonable support for the jury's decision? Do you follow what I'm saying here?
I do. The court made the determination as a matter of law that nothing was there. That's where we are.
Okay.
Wasn't the court's determination, or wasn't the standard that the contract has to be, as a matter of law, sufficiently definite to enable the court to ascertain its exact meaning and to fix the legal liabilities of each party? And if the agreement of the parties orally was nothing's going to change except ownership or authorized officer, that wasn't really true, was it? I think you pointed out earlier there was a number of things that Randy used to do that he no longer could do. He couldn't go to FedEx, he couldn't drive the truck, he couldn't wear the uniform. And so what were his responsibilities as a matter of the contract? We don't know.
We don't know. We don't know what the contract was.
And isn't that what the court ultimately determined? That it wasn't just a matter of the duration of the term, it was a matter of what are the legal responsibilities of each of the parties with respect to this contract, because the situation on the ground had in fact changed. There were things that Randy no longer could do, so what was he going to do?
That's basically what the court indicated, yes.
But is the issue, if somebody explains, a witness says, well, this is what I was going to do, then whether or not it was legal in FedEx's eyes isn't something that was raised below. So then are we free to say, the jury can't assume that what he said he was going to do was a part of the contract?
I think that's correct, yeah. Just on the conversion claim, I suppose I'm almost out of time, so just to address that briefly, judge found that in 2018, it was undisputed that Heather was the sole stockholder of BEI. And at the time, Randy had no legal interest in BEI and no right to demand anything. The gist of conversion is basically that the person claiming property has a property interest in the property claimed and a right to possession. Heather owned the stock. Randy had no right to conversion, and I would suggest that the court's ruling as a matter of law in that matter is correct.
Thank you.
All right, thank you.
Ms. Drake, can I ask you this? Do you agree that the unjust enrichment count and the contract count are mutually exclusive? In other words, if we were to agree with your argument on appeal to reinstate the contract version, that nullifies the unjust enrichment?
No. No, not at all. Balls and strikes, that issue was never presented to this court. That argument is completely forfeited.
No, I think,
No.
let's re-articulate
Yes.
this. You can either win a breach of contract because there is a contract, and if there isn't a contract, then you get an unjust enrichment.
But you don't get both.
You don't get a double recovery.
I'm not disputing the concept, but procedurally, there was no challenge on that ground made to
Okay.
this court.
So you're saying that if we were to reinstate the jury's verdict on the basis of your appeal, because we think there's a contract, you still get the unjust enrichment verdict as well?
In light of the
judgment as
way
well.
that this case is presented to this court, in much the same manner that this court wouldn't reach beyond the claims that we've brought to it, breach of contract and conversion, and decide the fraud count or any of the other counts. That just
Let me
there's
ask you
no
another
cross appeal.
question.
It didn't come up.
Let me ask you another question. If we were to agree with you that there, on its face, might be enough evidence to have the contract claim go to the jury, if the evidence of the actual damages that the jury awarded is really speculative in terms of what the damages are, in other words, just assume that we think that the damage award is not supported, even if arguably you might have been able to go to the jury on the contract. Doesn't that also mean it gets affirmed below?
No, there was no dispute. Nothing in that regard was raised either in the trial court or before this court. There is no cross appeal. There's no argument that's presented in the briefing with respect to.
But isn't that an
number.
alternate ground? My point is if the damage evidence is too speculative to support the damage award, isn't that an alternate ground for affirming the court's decision on the contract?
If I may.
Yes.
Well, first of all, I don't believe there's any evidence in this record from which this court, viewing in the light most favorable to the award, that it's too speculative. But even if it were, that was not a point that was brought before this court for its consideration.
Okay.
Thank you.
Thank you. Thank you, counsel. As is our usual practice, we'll be taking this matter under advisement and issuing a written decision in due course. And with that, I think we're in recess for the morning.
All rise.